Good afternoon, everyone. It is my pleasure to welcome you all to the final rounds of the third DBRANLU National Moot Court Competition 2026 in collaboration with NHRC. Over the past few days, we have witnessed exceptional advocacy, rigorous research, and commendable dedication from all the participating teams. Today's finalists have successfully navigated multiple challenging rounds, and their presence here reflects their remarkable skill and perseverance. We are also deeply honored by the presence of our esteemed judges, whose guidance and expertise make this round truly meaningful. With this, I wish both the teams all the very best. Thank you, and let the final round begin.
Good afternoon, everyone. Welcome to 3rd DBRANLU National Moot Court Competition 2026 in collaboration with National Human Rights Commission NHRC. I hope everyone present in the courtroom is concerned with the current proceedings of the court. We shall now begin with the introduction of our honorable judges on the bench. We have Honorable Mr. Justice Ajay Bhanot, sir, with us. It is an honor to have you with us, sir. Our second judge for today is Honorable Mr. Justice Pankaj, Jain, sir. We are grateful to have you, sir. Our third judge for today is Honorable Miss Justice Mini Pushkarna, ma'am. It is an honor to have you with us, ma'am. Our fourth judge for today is Honorable Mr. Justice Prakash Shukla, sir. We are grateful to have you, sir. Our fifth judge for today is Honorable Mr. Justice Ashok Kumar, Jain, sir. It is an honor to have you, sir. We have TC 19 and TC 73. The counsel for petitioner is TC 19 and the counsel for respondent is TC 73. The minimum time per speaker, as already mentioned, is 15 minutes per speaker. The breakup for oral proceedings of counsel for petitioner is time reserved by counsel 1 is 15 minutes, time reserved by counsel 2 is 18 minutes, and time reserved for rebuttals is 2 minutes. The breakup for oral proceedings of the counsel of respondent is time reserved by counsel 1 is 16 minutes, time reserved by counsel 2 is 16 minutes, and time reserved for the rebuttals is 3 minutes. For both the claims, the first bell warning will be given when half time is remaining, the second bell warning will be given when 7 minutes are remaining, and the third bell warning will be given when 5 minutes are remaining. The last bell warning will be given when only 1 minute is remaining. Kindly note that the mentioned breakup is per speaker, not per team. We hope that the counsels and co-counsels are well versed with the court rules. With due permission of the honorable bench, the court is now in the session.
To the Honorable Bench, I'm counseling for one on behalf of petitioners along with my co-counsel. My lords, both of us would be taking 16 minutes of the court's time per speaker in submitting on all the 4 issues. And now, if my lords may allow me to lay down the pertinent facts of the case.
If my lords may allow me to lay down the pertinent facts of the case, much obliged. My lords, in the state or in the region of Sultanabad, Kishanganj region, a coordinated digital misinformation campaign began. Now, it was using the GAN-based deepfake video, and my lords, nearly 12,500 AI-powered bot accounts spread the fabricated content across the city, allegedly funded by the foreign actors through rupees 43.7 lakhs in cryptocurrencies. As a result, there was public unrest in the particular region, and that too of communal in nature. Now, to curb the misinformation, the state imposed internet shutdown as per section number 5, subsection 2 of Indian Telegraph Act 1885 and temporary suspension rules 2017. My lords, with my lords' permission, may I please begin with the formal submissions? Much obliged. My lords, considering that issue number 1 deals with the tests of proportionality, necessity and least restrictive alternatives available, whereby I shall be dealing with article number 14, 19 and 21 of the Constitution of India. Also, with respect to issue number 3, it pertains to reasonable restrictions under article 19 clause 2. Now, if my lords permit me, shall I begin with both the submissions collectively? Much obliged. My lords, Constitution does not permit the state to fight misinformation by silencing the whole city. My lords, how can the national security be considered as a constitutional blank check? My lords, if today in this honorable court such sweeping powers are accepted, then every digital crisis could justify a digital blackout which can result into something which is very irrelevant and incompatible with the democratic institution of India. My lords, now I shall be dealing both of these two issues in 4 submissions. The first submission, that there was a failure of the test of proportionality. Secondly, there was failure of the test of necessity and least restrictive alternatives available. Thirdly, that there was failure of the reasonable restrictions justification under article number 19 clause 2. And lastly, my lords, that there was violation of article number 19 and 21 of the Constitution of India. With this, my lords, I would like to begin with the first submission, that there was failure of the test of proportionality. My lords, proportionality, it means that reasonable measures should be taken and they should not be excessive in nature. Lords, it is a well-established rule that yes, restrictions can be imposed on fundamental rights of the people, but they should pass the test of proportionality. Lords, specifically speaking about internet shutdown, in a very landmark case of Anuradha Basin, my lords, may please refer to page number 83 of the compendium. Whenever my lords are with me. My lords, there it is stated that yes, internet shutdown can be imposed, but it should be proportionate, temporary and subject to the judicial scrutiny. My lords, the petitioners would like to contend here that the measures so adopted by the state are grossly disproportionate. And why the council says so? If my lords may please refer to paragraph number 4 and 5 of the Moot proposition. If my lords are with me. My lords, it is a point to be noted that communal violence was at its peak on the 3rd day, that is 23rd of July. And my lords, the internet shutdown was imposed on 22nd July. Now my lords, in the 5th paragraph, it is written that situation began to stabilize. Now if situation began to stabilize, why there was no leniency given to the with respect to the internet shutdown to the people? Why the fundamental rights of the people are curtailed in that situation also? Well, lords, now the respondents even cannot argue here that they were not aware about the subject matter of that particular video, or they were not aware that how this particular deepfake video was circulating. Well, Lord, they did a very great job. They began an investigation, and what was the result? We got to know that it was GAN-based deepfake technology. Now, if I may take a moment to explain that what this technology was and how typical it was. Well, lords, it has 2 basic essential elements. The first being the generator and secondly detector. Now, generator generates the video to that generates and refines the video to that extent that the detector is unable to find whether this particular doctored video is something which is deepfake or original. Now, my lords, considering that's how typical it was, technological problems need technological solutions.
The bench has a question to you. Now, given that this viral deepfake video, which you said, had already triggered violence across 12 localities in this area and was being intensified through bot networks and also coordinated online activity, then how would you explain that this only 23-day internet shutdown affecting approximately 4.7 million was not a necessary measure to prevent further circulation of the content and escalation of violence? Was this not a duty of the state to ensure that violence is curtailed?
Perhaps this only brings me to my second submission, that when there are least restrictive alternatives available and the same objective can be achieved by applying some measures which restrict the fundamental rights in a lesser proportionality, then why those measures were not adopted? Now here the state may contend that it was in the interest of national security and public order. But my lords, as I previously stated, national security cannot at all be used as a constitutional blank check. Why, my lords? Because alternatives did exist. For example, my lords, they could have even blocked the deepfake under section number 69A of the IT Act. Secondly, my lords, they could have seek help and coordination from the social media platforms to remove that particular video. Thirdly, even they could have disabled the vote accounts. Not just that, my lords, even if today we consider that all of these three measures were not efficient to curb that particular situation, then also, my lords, they could have imposed internet restrictions in only those localities where the violence erupted. Now, my lords, as per paragraph number 4 of the Moot proposition, it explicitly states that in only 12 localities, the violence erupted. If the answer suffices. Pardon, my lords?
Word of the Arab Spring.
Adam Spring.
Arab, not Adam.
Arab Spring.
Not Adam Smith. Arab Spring.
Pardon, my lords.
ARAB. Arab Spring. SPRING. Has anyone heard of Arab Spring? The first thing that you do is when you're pressing a phone, stand up and it. Arab Spring was a incident which had occurred in recent times, which demonstrated the power of internet and internet-based narratives, fake or genuine, to bring down government. So that is an aspect that you may like to consider and address, because the power of internet is something which has not been in human hands so far. So the authorities have to evolve standards to meet that power. What do you think should be those standards?
Well, let's considering the situation only. Now, if we consider that yes, internet shutdown can be valid for 1 day, 2 days, even 3 days, even, my lords, if we consider, for example, 1 week, then, my lords, 23 days, my lords, it is not at all justified. Why the council says so? Because since the situation began to stabilize and we have other alternatives available. My lords, here the respondents may argue that, for example, geofencing was not efficient enough. For example, section 69A, URL blocking was not enough. My lords, if I may suggest a very unique solution that is very reasonable enough, my lords, it is prudent. My lords, they could have imposed the internet restrictions on 12 localities and then simultaneously they could have disabled the bot accounts that were artificially amplifying that particular video. Also, my lords, they could have seek help from those social media accounts to just ban that particular video. But how can we say that there is guarantee that after the internet shutdown is taken off, that the replica of that particular video is not available with someone else's laptop? Lords, it could have erupted. If I may take example of an analogy,
Just a moment. So the very fact that you said that the video was being circulated and it could not have been curtailed, then don't you think the state was well within its right to ensure that that there's broader restriction by the state had to be exercised in this situation, especially when the investigation ultimately came to know that the deepfake video was initially uploaded through a foreign IP address?
Lords, the council is not contending here that this particular measure was not sufficient. indeed it was. If the violence has stopped, if the violence has stopped because of this internet shutdown, then it is sufficient enough. But my lords, another point which comes is whether it was necessary or not. My lords, here in this case, if we, for example, we choose some alternative which restricts the fundamental rights of the people in a lesser propensity, then why not to choose those fundamental rights? If I may quote some numbers which are very grim in nature, that people has to suffer so much. My lords, 1,850 crores of businesses has lost. Not just that, my lords, 28,000 gig economy workers has lost their livelihood. And if I have to quote something very grim, then my lords, the assets of this country, the students, lords, they had lost the internet access, the online education, and the number is even more severe. Lords, 1,85,000 students. My lords, another interesting point to quote here is that it was a metropolitan region. My lords, it was not Jammu or Kashmir or some other area which is far-fetched where such conditions are recurring. My lords, considering it was a metropolitan region, it is to be noted that internet is an intrinsic part of that particular region. It's like a lifeblood, like soil, my lords, like, for example, water. So it is stopping them. Now, my lords, this brings me to my third contention, that why these restrictions were not reasonable. Lords, if I may quote a very landmark judgment of Modern Dental College versus State of Madhya Pradesh, my lords, can find the same in page number 178 of the compendium. My lords, there the 4 tests are given, from where we can see that whether any measure taken is proportionate or not. First being the legitimate aim, secondly, rational nexus, thirdly, necessity, and my lords, fourth is balancing. Now, my lords, even if we consider that yes, the legitimate aim was good, it suffices the situation that to curb the national security and to maintain public order, it was imposed. Yes, my lords, we agree. Coming out to the second contention with regards to the rational nexus, we agree that it was needed. Now, my lords, coming on to the third contention and fourth contention, now the question arises, necessity and balancing, my lords. If it could have been...
Once you refer to the compendium, you refer to the judgment, read that relevant paragraph. After that, on the basis of that, you build your argument.
Well, it is written in the paragraph only that 4 tests are given to test proportionality.
What is observing is that in court proceedings, whenever you're relying on a judgment, then you give the cause title and the citation, and thereafter place the relevant paragraphs by reading them.
Pardon, my lords, I will take this into consideration.
You are going with the presumption that the judges know.
Pardon, my lords.
Yes.
I will take this into consideration.
The presumption is to the contrary.
No, wait.
I know. Yes.
Now, my lords, as per the paragraph number 53, it is hereby stated that there are 4 tests: legitimate aim, rational nexus, necessity, and there should be balancing. Lords, as the petitioner has contended that yes, legitimate aim, the test passes. Yes, coming on to the rational nexus, the test passes. But now coming on to the necessity and balancing, how is it completely relevant or proportionate when we see that lesser restrictive alternatives are available? Now, my lords,
What are those lesser effective alternatives?
my lords, blocking of the deep fake through section number 69A of the IT Act could have been adopted. Not just that, they could have disabled the bot accounts which were artificially amplifying that particular video. Thirdly, my lords, they could have seek help from the social media accounts to ban that particular video. Lastly, my lords, the most important, that they could have restricted the internet access to those localities only where the situation was very grave. If the answer suffices.
Just last, you say that you should restrict it only in that area. You think with the coming of internet, localities matter?
Pardon, my lords, if you may
With the
please.
coming, just get to look, yes. So with the coming of the internet, locality-based restrictions matter.
My lords, here in this particular situation, it matters. Now, why? My lords, simultaneously, 2 things could have been done. For example, if we say that we impose internet restrictions on 12 localities,
simultaneously we could have taken the technological measures like blocking of the blocking of the bot accounts and blocking of that particular content. My lords, in this way the situation could have been addressed. Now, my lords, I would like to contend here is that respondent did not even pay heed to it. Lord, state was supposed to surgically remove this particular misinformation, but what the state did was completely imputing the digital infrastructure of the country.
Therefore, the bench has another question here. You just mentioned Section 69A of the Information Technology Act. Now, as per this section, blocking operates at the URL or the domain level. And deepfake in this case was being re-uploaded constantly through the TOR, that onion router network. So given that when the TOR is inherently defeats the URL specific blocking, then how Section 69A would be an alternative effective way by the state at this position?
Thank you, my lords, for the question. But my lords, here another point to note is that we are not contending that, for example, any one alternative or two alternatives could have sufficed. But my lords, three alternatives together simultaneously being adopted could have sufficed this situation. How? As the council has stated before, that imposing restrictions on the internet access on the 12 localities, thereby simultaneously blocking the URL network and blocking of that particular video. My lords, what would happen by this way is that now the dissemination is stopped, for example, in those 12 localities. Now, curbing that situation through technological measures could have sufficed this situation. If the answer suffices, much obliged. Now, my lords, this brings me to my final submission that there was violation of Article number 19 and 21 of the Constitution of India. Now, my lords, as per the judgment, the landmark judgment in internet shutdown of Anuradha versus Union of India, it was held. If my lords may please grant me an extension of just 1 or 2 minutes to just submit.
Continue.
Thank you, my lords. My lords, as per the landmark judgment of Anuradha, it was held that freedom of speech and expression through internet is protected under Article number 19 of the Constitution. Now, my lords, considering in the contemporary situation that internet is central to the democratic communication and dissemination of the ideas, this particular situation, this measure which the state has taken up is completely irrelevant. What happened as a result, my lords? Internet shutdown has silenced the digital news platform. Now, as per the paragraph number 23 of the Moot proposition, it is there stated that now the fact-checking organization is unable to counter the misinformation which is now circulating in an offline setup. Well, ironically, the state imposed the restrictions. Why? Because they wanted prevention. But what happened? Well, it added fuel to the situation. Now this brings me to my second contention, that how this is violative of Article number 19, Clause 1, Subclause G. My lords, 28,000 gig economy workers had lost their livelihood, and to talk about the permanent loss, my lords, 340 startups faced severe operational paralysis, and amongst them, my lords, 7 shutting down permanently. My lords, therefore it is violation of Article number 19, Clause 1, Subclause C. And coming on to the final submission, that how there was violation of Article number 21. My lords, as per a very landmark judgment of Menka Gandhi versus Union of India, my lords can find the same on page number 251 of the compendium. My lords, it is just a moment, my lords. My lords, as per the paragraph number 40 of the same compendium of the case of Menka Gandhi versus Union of India, it is written that any deprivation of liberty can happen, but it is subjected to the test of fairness, justness, and reasonableness. Now, my lords, by these three words, it again heads back to the test of proportionality and necessity, which the council has established before. My lords, here the shutdown has disrupted healthcare services, telemedicine communications, educational access, and my lords, essential digital finances. Now, if my lords does not have any further questions, I would request my co-counsel to proceed with further submissions. Much obliged.
please the court, the counsel seeks permission to address this bench, honorable bench, on issues number 2 and issues number 4. My lords, before I proceed with my humble submissions, may I take a moment to quote Mr. Charles Dickens, a renowned English author, from his famous work, A Tale of Two Cities. He says, and I quote, "It was the age of wisdom, it was the age of foolishness. It was a season of light, it was a season of darkness. It was a spring of hope, it was the winter of despair." What the respondents have done in this particular case, my lords, is to nothing but create a winter of despair and a season of darkness over the region of Sultanabad Kishanganj by bypassing the essential procedural safeguards that are necessitated for imposing a grave order like internet shutdown. While the state continues to justify these actions as a spring of hope for national security, lords, the petitioners contend that what the actual aggrieved are those who have already lost their fundamental rights, and we cannot be restored to the same situation, my lords. Lords, with that I shall proceed to my first submission, if I may have my lord's kind attention to paragraph number 18 of the Moot proposition. If my lords are with me. My lords, preceding this paragraph, you will find an order that was issued by the state authorities which curtail the fundamental right to express your freedom of speech and expression through internet for a total of 23 days. But the initial order was limited to 72 hours. However, my lord, this very order was not published until the 9th day of its issuance. Now, what does this 9-day delay constitute, my lord? It is effectively extinguishing my right to come before this honorable court. So, for the first crucial week of this internet shutdown, I was rendered helpless not to be, I cannot approach this honorable court because I didn't have any cause of action to show. So, my lord, post the 9 days, they did publish the order, but that too also after media scrutiny and pressure. So, the respondents cannot take this defense. They are acting in good faith in justification of the welfare of the citizens by not publishing the order because they had been subject to media scrutiny which forced them to publish the order. Otherwise, they would have went without publishing this order.
Now, tell me at this stage, why did you not approach the bench, the court, immediately after the 9th day when the order was published and you waited for so many days after those extensions?
Let's, to answer your question, may I take
will not the court feel that there was no immediate as such this delayed response on your behalf? Can we not assume that there was no immediate harm to you?
My lord, the immediate harm was absolutely upon us that we could not approach this court, and one of the pertinent reasons that was also mentioned by my co-counsel that violence was being carried out in the Sultanabad Kishanganj metropolitan region at this period of time. So there were certain safety concerns that needed to be kept in mind before approaching this court. My lords, what we did immediately after the 23 days that we came before this court, one of the other reasons is, my lord, that this 72-hour order was extended for a period of 7 times by the executive. So the order did not end on the 9th day, my lords. They kept on extending till the 23rd day, and with it came the extension orders, which were absolutely vague and generic justifications.
So your grievance is against the order or the extension thereof?
My lord, in absolute in the internet shutdown for 23 days, the original order was also illegal, and even the extension orders I shall take in the further submissions, my lord. My lord, it is an established judicial fact that for an order to be prescribed by law, it must be brought to the notice of the citizens who are affected by it. My lord, in the landmark case of this honorable court in Haryana versus State of Rajasthan, which my lords will find in page number 344 of the Moot compendium. Page number 344, my lords.
Yes.
My lords, I read, and this is the judgment of the Supreme Court, my lords. Natural justice requires that before a law can become operative, it must be promulgated or published. It must be broadcasted in some recognizable way so that all men may know what it is, or at least there must be some special rule or regulation through which one can acquire the knowledge of the order. Now, my lords, natural justice demands publication in this present matter. If, my lords, imagine this situation, one fine morning we wake up and we find that essential services like internet is absolutely taken away from me without any reason justification, my lords. The whole grim has been pointed out by my co-counsel.
So what is the alternative? Suppose there is a shutdown and then no orders are being passed. So in the absence of orders, you are bereft of any remedies. Is that your submission? That if you don't have an order with you, you don't have the possibility of approaching the courts for your enforcement of fundamental rights. You think the remedy is extinguished by that fact?
I cannot challenge, because I don't have the order, I do not have a cause of action with this Honorable Court. So I cannot challenge the order on the gross illegality that the order has been carried out. Even if my lords would follow that the temporary suspension rules also make a review committee. A review committee must be set up so that there is an oversight over the entire exercise, whether it is proportionate or not, my lords. Now, if my lords may follow me to the statute compendium.
What is your understanding of cause of action?
Cause of action is the direct incident that which infringes my fundamental rights in this particular case, which I can challenge before this Honorable Court.
So your cause of action is the stoppage of the internet or the passing of the order?
The stopping of the internet, if stopping of the internet is not in question, that was dealt with by co-counsel. My particular cause of action in this matter is the order that was not published. So I was not being made aware of the limitations to my fundamental rights that was being made. What the petitioner contains is not the internal deliberations of the executive. That is a privilege that the state can keep to themselves. What we are asking for, my lords, actually is publish the orders. For the straight 9 days, my lord, there was not even a single communication led by a speaking order, my lord. It is it's established fact that reasons are the lifebloods of transparency of an order. Neither was an order made, nor was any justified reason given that on which basis you are curtailing my fundamental rights. If my lords may follow, please pay kind attention to the statute compendium. Lords, the Rule 2, Sub-Rule 5 sets up the review committee. The review committee's job is given in Sub-Rule 6, which says that the review committee shall meet within 5 working days of the issue of the directions for suspension of services due to the public emergency or public safety, and record its findings whether the directions issued under Sub-Rule 1 are in accordance with the provision of Subsection 2. So what this statute makes the review committee, my lords, is a policeman of the law. It has a very important role to play, my lord. It had to record the recent findings that whether this exercise that was being carried out by the executive was in proportionate with what the Parent Act allows it to. So, but my lord,
The bench has a question here with respect to the reasoning aspect which you're saying. See, the requirement of reasons in administrative orders, it flows from Article 14 of the Constitution. And the courts have consistently held that reasons need not be elaborate in security contexts. But then how do you distinguish between inadequate reasoning, what you're saying, or the brief reasoning which has been given by the review committee? And secondly, how do you say that the reasoning in the shutdown or suspension order and the subsequent extensions in the present case is not is inadequate and not merely brief?
Well, to answer your first question, that the administrative law dictates that sometimes reasons can be even not given due to the privilege that has been in the state in respect to public emergency. Well, the thing is that had they not provided reasons, then under the justification of public safety or public emergency, then it could have been a cause. They gave reasonings for the extension orders. We are not questioning the reasonings of the original shutdown order, and that has been absolutely complied with, that there was to safeguard the ongoing investigation. But the extension orders came on coming every 7 times the extensions have happened. What the reasoning contained were weak and generic justifications. Now, the administrative law also states that if you are passing a speaking order, it should not be grossly violative of Article 14. It should have a reasonable justification if you are providing my notes. In this case, they have provided the reasoning, which is absolutely grossly vague and generic, which does not give me any reason that why, my lords, these people are, the respondents are curtailing my rights under the Article 14, 19 or 21, my lords. To answer your second part, my lords, if I may have a clarification of the second question again.
No, the second question is with respect to that the reasoning in the shutdown suspension order and the subsequent extension, why cannot be said that it was inadequate and not only merely brief as the state would do?
if you come to paragraph number 17 of the Moot proposition, the justification originally given was prevent further circulation of the deepfake, disrupt real-time coordination, and etc. etc. Now, what was the next process? That a review committee will sit. It will record its recent findings, and if it finds that if the exercise is proportionate, then they will go on with the order. So, once the review committee sits, there is a reasoned application of mind, and with that comes a reasoned order. So, but in this particular case, if my lords may follow me to paragraph number 18, the review committee met only once in the timeline of 23 days, my lord. So, what we are questioning is that whether there was a reasoned application of mind behind the exercise, my lords. Had there been no reasoned application behind the imposition of the extension orders, then these extension orders are grossly illegal under Article 14. Instance, my lords, this honorable bench gives different procedures for the petitioners and the respondents, and substantive justice is achieved on that. Then, my lords, this cannot be this is grossly violative of Article 14. This is the same thing that the respondents have done in the present case. And my lords, if I may refer you to page number 66, para 79 of the Anuradha Basan judgment, my lords. My lords, this is the words of this honorable court, not mine, that it must be noted that although substantive justice under the fundamental rights analysis is important, but procedural justice cannot be sacrificed at the altar of substantive justice, especially when the case concerns fundamental rights. My lord, this was also recognized in Maneka Gandhi versus Union of India, as well as Justice Case Puthuswamy. So this is an established fact, my lords. If you are taking away my fundamental rights, you have to give me reasons. I am not asking for the deliberations of your committees that you are the deciding factor behind these orders. I am only asking for the orders, and if you are publishing reasons, the reasons must be at least suitable for reasonable classification, my lords. Now, if my lords have no further questions on this issue, I shall proceed to the next.
What is reasonable classification?
My lords, if for example, in this case, my lords, the state has pertinently restricted the rights of the accused, the 4 prime accused that were curtailed of the freedom of right to access online digital, that I will deal in the next issue. So, if the state is reasonably classifying these section of people and giving the justification that in necessity of public emergency, we can curtail your rights absolutely, then you have to give me a reason, my lord. That's what the council wants to mention. My lord, if I may proceed to the next issue, that is issue number 4, my lords. My lords, the issue number 4 is even a graver issue. Now, given that we are talking about 4.7 million people's rights, in this particular matter, my lords, there were 4 prime accused that were identified by the state. And these 4 prime accused were subjected to absolute remediless, and there was no opportunity given to these 4 accused to present a proper defense before this honorable court, my lords. My lords, if I may take your attention to paragraph number 24 of the Moot proposition. My lords are with me?
Yes.
Perhaps most crucially for the accused, the administration of justice itself was hampered. Why? The defense lawyers for the 4 main accused and the others could not access online legal databases. Secure communication channels with clients, including encrypted platforms, were interrupted. Lawyers could not retrieve or review digital evidence, use e-filing portals for court submissions. Coordination with cybersecurity specialists and forensic experts located outside the shutdown zone became extremely difficult. Now, my lords, it is an established principle from this honorable court through the case of Sovran Singh Prajapati versus State of Madhya Pradesh, that defense, every accused has a right, indispensable right to have a proper defense before this honorable court. Now, what the respondents have effectively done here is that to restrict every form of the evidence collection by the accused, may it be secure communication channels with the clients, or coordinating with the cybersecurity specialists or the forensic experts located outside the shutdown zone. So, my lord, under Article 22 of the Constitution, the accused has an indispensable right to be defended by a legal practitioner of their own choice, my lords. Now, in the very same case of Sovran Singh Prajapati, this court recognized that a legal practitioner should not be limited to the merely being a lawyer or an advocate. My lord, he must have the proper knowledge of law, and he must be given access to proper information and evidence to establish the proper defense before this honorable court. Otherwise, what is the prejudice against me, my lord? The prejudice is that I will be rendered defenseless and I will be asked to incriminate myself in front of this honorable court because I have no narrative to rebut what the government is saying. So, my lord, through this, what we have done is to not only restrict my Article 22's defense by a practitioner of my own choice. Also, my lords, they are making me they're making me incriminate against myself against my own will. Now, how this is also substantiated, my lords, if my lords may come to paragraph number 20. Apologies, my lord, paragraph number 14.
Tell me, you talk about your rights under Article 22
My lord.
For a council. Suppose if the state had refrained from imposing the internet shutdown as in the present case and the situation had escalated further, would not have resulted in more loss to life and property, and the rights of the people under Article 21 of the Constitution would have been then violated?
My lord, if I may have your attention to paragraph number 17 of the Moot proposition, certain exemptions were granted when the internet shutdown was imposed. Government offices were given exemptions, landlines were given exemption, and hospitals with special authorization. So if you are giving exemptions, why not give exemptions to these four accused or the defense lawyers accused of these four accused to have an access to the internet to prepare a proper defense for this honorable court, my lords? If that suffices that. Lords, further, if you may come to paragraph number, my lords, if I may seek an extension of 1 minute to just conclude my arguments. If you may come to paragraph number 14 of the Moot proposition, my lord, there is one of the prime accused, Rizwan Ahmed. His only fault was that he was doing a job. Now, what I mean by a job is, my lord, he created this video that is particularly in question. But as he has vehemently said this fact that he was paid 8.5 lakhs in Bitcoin and he had no idea his work would be used to incite violence. Now, my lord, this very evidence is the sole reason given by the state to prosecute him and present as evidence before this honorable court. Now, my lord, even if you are doing this against me, at least give me an opportunity to rebut this narrative, my lords. You're denying my defense counsels to coordinate with cybersecurity specialists. You're denying my counsel to have any secure communication channels. And my lord, the respondents can argue that we have the other alternatives could have been exercised, like physical movement, telecommunication channels. My lords, it is one of the most important tenets of a fair trial is that both parties have the same path before this honorable court. My lord, in this, the government has the power of having the digital evidence and all kind of evidences, but we do not. Hence, the accused is wrongly incriminated before this honorable court. My lord, if that suffices, may we proceed towards the prayer. My lords, we pray before this honorable court to declare this impugned internet shutdown order as constitutionally illegal and a dead letter in law, and the procedural lapses that occurred, say namely the 9-day delay, the review committee's improper conduct, and the extension orders without reason constitutes a gross procedural error violating Article 14 of the Constitution of India. And my lords, not considering the least restrictive alternatives and imposing a grave internet shutdown like this also violates Article 1921 of the Constitution. Finally, my lords, the four prime accused, Article 20, 22, and 21 have been violated by this court. And also, it make a special request as honorable bench that, my lords, this is a continuous fact that these respondents, these states are doing these kind of situations and coming before the court, and we do not have the chance to restore the normalcy. But at least this honorable court through today make a strong guideline that if this is continued, that procedural lapse have been occurred with the internet shutdown, then, my lords, the respective officers will be prosecuted and penalized for the same. Thank you, lords.
The council is dealing with issue 1 and the council is dealing with issue 3. The council seeks permission to go deal with issue.
clearly submitted that the 23-day suspension was a temporary and a preventive measure taken to control an unprecedented digital threat that had already resulted in violence, loss of life, and the action was proportionate, aimed at restoring public order, and does not violate Article 14, 19, and 21 of the Constitution. It was held in the K.S. Puttaswamy versus Union of India, the doctrine of proportionality that mandates the state action must be necessary, proportionate, and to the object sought to be achieved. The fourfold test requires legitimate aim, rational connection, necessity, and balancing. The state has done the suspension, and it was imposed in the restriction to the circulation of GAN deepfake video that was amplified through bot network, encrypted platforms, cross-border routing, and cryptocurrency link coordination, resulting in metropolitan scale communal disturbance. The objective was to prevent further circulation of the deepfake, disturb real-time coordination of violence, protect communal harmony, safeguard the ongoing investigation, and address what was described as a national security threat. Protection of public order and security of the state are expressly recognized grounds under 19 Clause 2 of the Constitution. The violence was digitally triggered and digitally amplified. The deepfake was not isolated misinformation. It was technological engineered, means a planned, bot amplified, VPN masked, and cryptocurrency supported. The restriction directly targeted the medium through which mobilization and incitement were occurring. There exists a clear rational nexus between the objective and the measure. This was not a case of single unlawful post or identifiable URL. The threat was decentralized, encrypted, cross-platform, rapidly self-propagating. In such circumstances, targeted blocking under 69A of IT Act would not have immediately neutralized encrypted coordination and automated amplification. When the threat itself was a network, which network-wide and technologically coordinated, a network-level response became necessary to immediately disrupt escalation and prevent further violence. The state guaranteed exceptions for landlines, certain government offices, hospitals with special authorization and emergency services. The measure was temporary and lifted once stability was restored. The suspension was not definite, thus the suspension does not fail the proportionality test. Article 19 Clause 1A subclause A and Article 19(1) subclause D was reasonably restricted in the interest of public order. In Anuradha Bhasin versus Union of India, the court further clarified that the restriction upon such fundamental rights should be consonant with the mandate under Article 19 Clause 2. The present restriction was to impose in response to a rapidly escalating digitally coordinated disturbance of public order, as within the deepfake video. Your Lordship, please refer to the para 2 of Moot preposition, where it has been mentioned that the digitally coordinated disturbance of public order, as within the deepfake video was everywhere, and by the end of 48 hours, it has been viewed by 12.7 million times and shared by 2,87,000 users across different social media platforms. And they have mentioned the inflammatory cells for retaliations. For ordinary residents, the video felt like a direct attack on their identity and belief. Rumors spread offline alongside online circulation and creating widespread fear, anger, and confusion within 2 days in the city. Streets now saw stone pelting, arson, and clashes between groups dividing along communal lines. Within 72 hours, violence erupted 12 localities, resulting in 3 deaths, including 1 police constable, 47 injuries, 9 police personnel, and destruction of 28 shops and 15 vehicles.
The bench has a question. Before making this order with respect to complete shutdown of the internet services, were other alternatives also explored and discussed and considered by the state?
Your Lordship, the violence, Your Lordship, please refer para 13 of the Moot preposition. From the state perspective, this looked like less like a local riot and more like a hybrid warfare and cross-border cyber terrorism. Your Lordship, the state need to take immediate actions upon it, because it was in para 10, metadata analysis trade the first uploaded of the doctorate video to an IP address in Karachi. the state needs to take immediate action upon it, because already there was a communal violence which has erupted, and there is already a loss of life of the people.
No, but the issue is when on day one, when you came to know about the doctored video and you have taken steps by just pulling the internet. All right. On what day? On second day, third day, fourth day? On which day the violence was under control? Whether it was continued till 23rd day, or it was controlled on 5th or 7th day. Thereafter, there is required to be some measures so as to restore the normalcy.
Your Lordship, much obliged, Your Lordship. Your Lordship, the state has already granted the exemptions for the people, and also on the very first day, the police were trying to control the situation as it is mentioned in para 5, and among them one police constable was also killed.
No, but that is not sufficient. You see, number is not sufficient. You see, on day one, when the violence was at peak, and thereafter on third day when it has lowered down, how many incidents of stone pelting were reported on 5th day or 7th day or 23rd day? Because you have to justify that, yes, it was required to carry on till 23rd day. And that's why we have blocked the internet.
Your Lordship, much obliged, Your Lordship. This was not only the matter of local riots. The state has also the state also had to deal with the internal as well as external pressure. Your Lordship,
But you see, the Moot proposition is blocking of internet in the commissionerate area, the local area. And whereas only 12 local areas are suffered because of the riots.
Your Lordship, please refer para 16 of the Moot proposition. Your Lordship, it was written that on 22nd July 2025, as tension remained high, the Commissioner of Police issued an order under Rule 2 Clause 1 of the temporary suspension of telecom services. Read with Section 5 Clause 2 of Indian Telegraph Act 1885, which effectively turned off the both internet, mobile and broadband across the entire Sultanabad Kishanganj metropolitan region, impacting 4.7 million residents over an area of 673 square kilometers.
Okay, please
It already had a huge impact.
Yes, yes.
Please continue.
Much obliged, Your Lordship. Your Lordship, Article 19, Clause 1, Subclause G, the trade and profession were temporarily restricted in the larger public interest. However, Article 19, Clause 6 permits reasonable restriction in the interest of general public. The economic impact of the temporary internet suspension, though unfortunate and was an incidental consequences of a security measure aimed at preventing further communal violence, loss of life, and widespread destruction of the property. The restriction was not directed at suppressing trade or economic activity, rather it was directed at disabling the digital infrastructure being used for coordinated mobilization that had already resulted in death and large-scale unrest.
So what is the reason for not publishing it for 7 days?
Your Lordship, already the communal violence has been erupted. The people has taken, please refer to the Moot proposition of para.
Is there any enabling clause in the law that allows you to not publish such orders for 7 days, or is there some time limit prescribed?
Yes, Lordship.
Good question.
Your Lordship, in Anuradha Bhasi versus Union of India, this Honorable Court directed that the order be published to enable challenges and a review. The authorities are directed to publish all orders in force and any future orders under Section 144 of CRPC and suspension rules. The court did not hold that delayed publication automatically renders the order void ab initio.
Good.
The direction
Appreciate.
ensure transparency and enable judicial review.
That's right.
Your Lordship, Article 14 and 21 is not violated and uniform action was reasonable as the state acted to protect life. If the government had tried to block it, the URL in certain district, people could have easily bypassed the rules by accessing the content from nearby district. That would have the restriction ineffective because the threat was same everywhere and moving very fast, it made a sense for the government to apply the restrictions uniformly across all areas. And the state's foremost obligation is preservation of life. 3 people were killed, including 2 civilians. 1 police constable and 47 people were injured among 9 police trying to control the crowd. Violence has spread across 12 localities and the administration faced imminent escalation. In such circumstances, temporary suspension aimed at preventing further death and cannot be characterized as unconstitutional deprivation of life. The state also provided exemption for essential services and emergency institutions like landlines, certain government offices and hospitals. The intention was not to impair the healthcare, education or legal access, but to stabilize an extraordinary situation. Security measures taken to prevent further fatalities and are consistent with Article 21 and not the violate of it. Your Lordship, this case involves the GAN-based deepfake technology, bot network, cross-border IP origin and cryptocurrency funding, encrypted coordination. This exceeds ordinary misinformation. It represents hybrid digital destabilization in matters implicating national security and coordinated foreign-linked digital interference. And the measures were preventive, not collective punishment, as the Constitution and the law recognize that the state has power to act preventively to maintain public order and prevent harm. Your Lordship, the Council seeks permission to proceed with the next issue.
Yes.
It is humbly submitted that the impugned suspension order do not violate the safeguards of transparency and procedural review. The action was taken strictly under Section 5, Clause 2 of the Indian Telegraph Act 1885, read with Rule 2 of the temporary suspension of telecom services, and remain within the constitutional framework recognized by this Honorable Court. While publication ensures transparency, neither Section 5, Clause 2 nor the 2017 rule prescribed immediate public disclosure condition precedent for validity. Your Lordship, as I have mentioned earlier, in Anuradha Bhasin versus Union of India, the court did not hold that the delayed publication automatically renders the order void ab initio. The direction was to ensure transparency and enable judicial review, not to create technical ground of automation invalidation.
The bench has a question. Now, if the review committee, initial there was publication and then it was extended. So if the review committee was able to meet only once and the internet shutdown was ultimately extended 7 times, what specific material or evidence did the state place before the review committee to justify continuation of that suspension for such an extended period?
Much obliged, Your Lordship. The review committee did meet and review the suspension. The rules do not mandate a fresh meeting after every extension where the underlying emergency continues. The extension arose from a continuous and evolving security situation in coordinated digital mobilization and cross-border routing. In Anuradha Bhasin versus Union of India, this Honorable Court recognized that review must ensure proportionality, but it did not prescribe multiple mandatory meeting upon every continuance of an emergency.
But you tell me one thing. If a particular act is prescribed to be done in a particular manner, and if same is not done in same manner, does it sufficient to declare invalidation of that act?
Pardon, Your Lordship, I didn't.
You see, when the rule itself prescribes that the internet blocking or the shutdown has to be ordered in a particular manner, and after certain days a review committee has to be convened and a recommendation is required, meaning thereby the rule itself prescribes that yes, you can extend, but with the certain condition. If you have not done that in accordance with that procedure, does it not invalidate the order passed by you?
Your Lordship, doctrine of substantial compliance, that the impugned action by the state are not violative of the safeguard and transparency requirements and fine protection under the doctrine of substantial compliance. The doctrine applies when a party complies with all the essential requirements but fails to perform a minor aspect which can be said to the core or essence of the requirement. The state had reviewed the suspension. The committee has reviewed the suspension, but due to the minor aspect which cannot be said to be the core or essence of the requirement, it has been mentioned by the doctrine of substantial compliance. In the present case, with the regards the publication of the shutdown order, there was merely a delay, but not an absence of the state action. Your Lordship, if you have further questions, the co-counsel will be dealing with that.
Thank you.
Thank you.
Counsel seeks permission to approach the bench collectively as your lordship, individually as ladyship and your lordship. Counsel seeks permission to begin with clarification and collectively explain issue 3 and issue 4. As my co-counsel has already explained, if you please refer to para 13 of the Moot proposition, from the perspective of the state, this looked less like a local riot, more like a hybrid warfare and a cross-border cyber terrorism. And if you look in the para 10 of the Moot proposition, metadata analysis traced first upload of doctored video to an IP address in Karachi, Pakistan. The upload video has been masked through VPN use, and the follow upload was routed via Tor network, deliberately hiding the real origin of the perpetrator. We know that we got the information that it was from Karachi, Pakistan, but still we cannot verify it because it has been masked through. So the question is not only about the riot, it is about the national security. It is a cyber terrorism as well as cross-border terrorism. So according to my issue 3, it is humbly contended that the present issue concerns constitutional validity of the temporary metropolitan trade internet suspension imposed in response to unprecedented coordinated digital threat. The question is not the gravity of the threat, but whether the state's response remained within the constitutional limits while fulfilling the duty to protect the sovereignty, public order, and national security. So here in the case, the state could have been used this utmost power and declared state emergency, or else 163 of BNSS, which is equivalent to 144 of CRPC. But the state did not want to suffocate its citizen. The state provided their citizen what they can do. The state only had a blanket shutdown on internet because the internet is affected. The state didn't completely suffocate its citizen. And also we need to know that what are the other measures that the state can be used. For example, Section 69A of IT Act only blocks the URL. The internet is a meta, and in internet, if we block one URL and it is an automation of bot, they can easily pop up with 10 other URLs. And also, even any amount of targeted technological response will be experimenting on state itself. State cannot afford experimentation at this process when there is a threat of national emergency, national security, as well as their lives of citizens. And if you look into the previously in riot, para 5 of the Moot proposition, by the time the situation began to stabilize, the toll was grim. 3 people were killed, including 2 civilians and 1 police constable. 47 people were injured. Among them, 9 police personnel were trying to control the crowds. So the state...
The bench has a question here. You just mentioned that there was a threat to the national security.
Yes, ma'am.
That's what you said. Now, attributing a cyber attack to a foreign state requires highly reliable intelligence and evidence.
Excellent.
And it's only if it's confirmed detailed in the facts of the present case. It was only an IP address in the neighboring state that was also masked.
Yes.
Then in the present case, having used this national security threat, then as a reason to suspend the internet, then does the state concede and state that it is only IP level attribution alone forensically adequate to justify designating this incident as a national security threat and attributable to a foreign
And for that, we need to look into para 12 of the Moot proposition. In that fourth point, it is mentioned that a cryptocurrency funding trial of 43.7 lakh, approximately USD 52,500 moving through Bitcoin, Monero, Tether wallets linked through UAE, Cayman Islands and Hong Kong. 73 disposable SIM cards, 28 burner phones for used for real-time coordination. So we can understand that this is not about the teenager who made a video for fun. So it is something more serious. Understanding the gravity and intensity of the situation, the state has no choice but to do that. The state can go on, use its utmost power and suffocate the citizen, but the state didn't do that. The state could have used the alternative measures, more than 3 or 4 measures, but it would be experimenting on its citizen. The state cannot afford experimenting on its citizen when it is about the sovereignty, integrity of the nation as lives of the citizen. And any fundamental right can be suspended, but not Article 21. Article 21 is at most cannot be compromised at any situation. And also we can look into that after the blanket shutdown, no lives were lost, nobody was injured, and the state accept and take responsibility that economically their economic losses were high. But the state's priority, state's primary concern is the life of the citizen and security and integrity of the nation. In that, the state performed its duty as well as responsibility. Also, if we looked at Para 21 of the Moot proposition, there was a 12-year-old child with rare metabolic disorder. In the Moot proposition, it is mentioned that because they curtailed the internet and communication, the child had to be airlifted. Even in that, even when state curtailed some rights, state provides the remedy as well as. State not only curtails the rights, state provides what it has to be done to the citizen. We need to really understand that state provided a blanket shutdown not to use its power. It is to save the citizens and also for the well-being of the state. And also when we look into that, the review committee met only once. Also the state hasn't declared. Again, we need to understand that this could lead to a hybrid warfare. So confidentiality has to be maintained. State could not disclose everything to its citizens. And also when we look into the proportionality test, legitimate aim, protection of sovereignty, security of the state and public order from coordinated digital operation involving foreign actors, anonymous funding clearly falls under Article 19 subclause 2. Rational nexus. Internet connectivity was channel enabling bot amplification, deepfake dissemination, and encrypted coordination. Temporary suspension directly disrupted this architecture. Necessity. Alternatives such as 69A, blocking platform, corporation, geofencing. My learned counsel suggested that we could have done geofencing, but the problem is they could easily bypass. The people would go near the border and they could easily exchange the information. So geofencing is pointless under these circumstances. And the internal issue is regarding religion. It is more sensitive. So anything the state should do, state should perform it with precision and accuracy. State cannot make random decisions. State cannot make minimalistic decision and put its security and life of citizen on stake. Balancing. The suspension lasted 23 days, was geographically confined, periodically reviewed, lifted once threat subsided. The inconvenience to the citizen was temporary. The risk coordinated. The digital unrest was systematic. As your lordship asked, why the why the suspension act was released, if you look into the para 16 of the Moot proposition, on 22 July 2025 at 6 a.m., as the tension remained high, the Commissioner of Police issued an order under Rule 2.1 of Temporary Suspension of Telecom Act, read with Section 5.2 of Indian Telegraph Act. So they took all the measures. First, they tried to control the crowd with police officers. The police were killed, as well as the people were injured. Also, school children now started seeing stone peltings, arson clashes between the groups. The state took all its precautionary measures traditionally, and it couldn't do that. Also, the tension remained high. That's why the state had no choice but to do the blanket shutdown. If your bench is satisfied with issue 3, I'll proceed with issue 4. it is humbly contended that the temporary suspension of internet services did not violate Article 20, Subclause 3, Article 21, Article 22. The measure neither compelled self-incrimination nor denied fair procedure or legal representation. It was preventive, time-bound, responsive, receiving the investigatory integrity and protecting the administration of the justice. Your Lordship, the Constitution guarantees a fair trial, not digitally optimized trial. The representation remained available, court remained open, and the temporary restrictions several the compelling purpose of protecting the integrity of investigation. If internet access were constitutionally indispensable to the legal defense, every power outrage in India could amount to the violation of Article 22. And also, my learned counsel has said that they couldn't produce their evidences, they couldn't work upon it. So everything, every procedure they were talking about should be happening in cross-trial procedure. And we have, the internet shutdown was only for 23 days. So in 23 days, it was not absolutely necessary, and every offline method was available. They were not curtailed that you cannot meet your lawyers, you cannot access your evidence. Everything was available. So it was nothing but a mere...
Yeah, tell me, when these allegations, you say that Article 22 violation was not there because they had access to their lawyers, etc. But when in this case, the allegations and charges against the accused are of such a technical nature, does not lack of access to the internet impinge upon their fundamental rights to the accused which they have under the Constitution?
Ma'am, first I would like to say that the petitioner didn't even ask for the court or anybody, that there is no record of them asking for any digital access or any such. They directly filed the case along with the petitioners that we didn't get any legal remedy. If the legal remedies, if they didn't get legal remedy, they should have asked it, if in their perspective. And all offline, everything offline is procedure, every offline procedure is still available. As I was saying, everything they mentioned should have happened in cross-examination, and in the 23 period of time, there is no way that cross-examination is going to happen. Also, I would like to say that the temporary internet suspension preserved evidence, safeguarded witness, ensured fair trial integrity, and maintained public confidence in justice system. Accordingly, it respectfully submitted that there was no violation of Article 20, Subclause 3, 21, 22 has been established. Because I also wanted to tell that they were arrested because of the digital crime they have done. If we give them access to the digital, so it is pointless that we are doing the blanket shutdown. So they can still misuse it. If the bench is satisfied with issue 3 and 4, counsel seeks permission to proceed with prayer. Therefore, in the light of the facts stated, issues raised, constitutional provisions invoked, authority cited, and arguments advanced herein above, it is most humbly prayed before the Honorable Supreme Court that it may be pleased to hold and declare that the 23-day temporary suspension of internet service was constitutionally valid, having satisfied the requirements of legality, necessity, proportionality, and reasonable restrictions under Article 14, 19(1)(a), 19(1)(g), and 21 of Constitution of India, declared that the impunged measure falls squarely within the scope of Article 19(2), 19(6), being preventive regulatory action and adopted in the interest of public order and security of the state and the general public. Hold that the procedural safeguard under 5.2 and the 2017 rules were substantially complied with, and that the delay in publication, the conduct of review committee, and the form of extension orders did not vitiate the suspension in the absence of nullified, manifest arbitrariness, or demonstrated prejudice. Recognize that the state's primary constitutional obligation under Article 21 is preservation of life and maintenance of public order, and that the temporary disruption of the digital service was undertaken to prevent further loss of life and large-scale destruction. Dismiss the present writ petition as being devoid of merit, and pass such order as the Honorable Court may deem fit, proper, in the interest of justice, equity, and good conscience. And for this act of kindness, the respondent shall be duty-bound forever to pray.
My lords, when I was hearing to my learned friend, one pertinent point that they have missed from the facts, which makes the entire arguments erroneous. If my lords may follow me to the Moot proposition. Lords, if I may have everyone's kind attention to the Moot. My lord, on the evening of 18 July, the video started circulating. It took 48 hours, that means 20th July. By 20th July, the video was viewed by 12.7 million, 287,000 users. Now in the next paragraph, my lord, third paragraph, rumors spread offline just as quickly as the video spread online, and within 2 days, the city was gripped by fear, anger, and confusion. So 18th, the video circulated. 20th, the video reached a high base. 22nd, by 22nd, my lords, when the internet shutdown was imposed on 22nd of July, there was no violence in the state of Sultanabad Kishanganj. The state preemptively did an experimentation which they were claiming the geofencing and other restrictive alternatives will be to experiment. They experimented with internet shutdown.
You think the state should wait for the violence to erupt and then it should?
Well, then
Only when they're in a position to prove that violence actually happened, then only they can impose these restrictions.
No.
Or the nature of these restrictions is to preempt violence.
absolutely, my lords, I agree and I absolutely understand where you're coming from. What the state's actions are here, they have restricted the internet. Had they been preemptively expecting of violence, why not impose section 163 of the DNS then? You could have restricted the physical movement. You could, what they contend, that the physical violence upon which they have substantiated the arguments for imposing the internet shutdown could have been prevented by imposing a section 163, my lord. They ignored that fact, my lords. Now coming to the review committee, my lords, my lord, my learned counsel stated.
No, but tell me, how would geofencing would have prevented further amplification, considering that the situation that the original upload was from a neighboring country?
My lord, as my learned counsel had already stated, that geofencing is not individually should be applied here. Geofencing should be applied with other least restrictive measures such as URL blocking. So by geofencing, as they mentioned that they could have easily shared the videos across the borders. Well, that's the state's responsibility to tighten the security in certain cases. And as already stated, had section 163 be instead imposed, then this concerns with geographical security in the state could have been easily alleviated by the state. Now coming to the further points, my lord, my learned friend mentioned that the review committee is not mandated to sit or mandated to sit only when the emergency subsides. My lords, may I go to page number 83 of the Anuradha Vasan judgment, and which is also included in the order part of the Anuradha Vasan judgment. It says, and I quote, that the existing suspension rules neither provide for a periodic review nor a time limitation. Therefore, we direct that the review committee constituted must conduct a periodic review within 7 working days. So within this 23-day timeline, my lord, they should have sat at least twice or thrice. They did only once and they are saying that it's substantially complied. Well, the core purpose of the review committee, well, just 30 seconds.
Here it is not as a principle, it has been laid down.
Well,
They should sit every 7 days.
Well, as a principle also.
This is in the facts and circumstances of that case, they said they should have sat within 7 days.
No, my lord, in the order, except for the order part, they have also laid down a principle in this case also. So, my lords, if I may take your my lords to page number 83.
How do you define a principle of law? What is the concept of a precedent?
Well, a precedent is binding on any future occasions of similar conditions. Now, in the Anuradha Vasan judgment, we were facing a similar situation of terrorism in Jammu and Kashmir. And even, my lords, in Anuradha Vasan judgment, the learned judges had taken consideration of cyber terrorism. And I read the directive in paragraph number 100. We therefore direct that the review committee constituted must conduct a periodic review within 7 working days of the previous review. So it is not limited to the order part in this case, my lord. Finally, just last point, my lords, that they had mentioned that if there is no record in the present case, my lord, if there is no record, then we will assume that there may be yes or no. We cannot simply assess that yes, that there is no record, but there must be an affirmation. There can be a negative affirmation also in this respect. Thank you very much.
I think they just do have rebuttal for 1 minute each.
Jawab ul jawab. Na jawab.
Council seeks permission to answer for the report. As my learned counsel has already said to me that rumor, according to para 3 of the Moot proposition, rumor spread offline just as quickly as the video spread online. So he said, why did we impose 163 of BNSS, which is equivalent to 144 of CRPC. The thing is, as something so sensitive as religious, its gravity increases and becomes more intense as the rumors spread online. Because in online, people become fearless; they can tell whatever they want. For example, in every tea stalls, in every cafe, we always have conflicts regarding religion and political thing. But that is not going to create any riot. Because that is not going to be, everybody is going to be mindful of what they are speaking in offline. But likewise, it is not going to happen in online. And in online, things are spreading in a rapid phase, extremely rapid phase. And realizing the gravity in offline, it is easy for the police force or everybody to control it. And also that after the internet shutdown, there is no reported cases or any violences. And only when the violence is increased, they have initiated the blanket shutdown as the last resort, not as the primary thing.
Just tell me, in the order of shutdown and subsequent review orders, did the order specify that other alternatives were also considered?
No, I don't understand your question.
Whether the other alternatives were also considered apart from complete shutdown?
Likewise.
Explored any alternative,
Sir, as I said that first we have used the traditional method. Police tried to control the riot and everything. And as we can take the judgment from another person, we cannot take the facts from another person, because there it is terrorism, here it is cyber terrorism. The means of terrorism itself is internet. So by taking that in account, we need to implement blanket shutdown. We have no other way. As I was already saying, it is not just a riot, it is a cyber terrorism and possibly hybrid warfare. So the state cannot experiment by imposing 69A and wait for a while and what happens. The state should make any decision in a rapid phase, because realizing the intensity of the case. So if my lordship is satisfied with the answers.
Thank you. Thank you.
Any further questions?
We extend our sincere gratitude to our honorable judges for their presence with us today. We deeply appreciate your commitment and the time that you have taken from your demanding schedules to be here. We are looking forward to have you on board on our next event. Thank you. Please, I kindly request you to please leave the courtroom for this meeting.
Whatever. Can't be no, that's right. My pencil says
their presentation, they were able to answer this question, they were able to answer the presentation was very good, very good. No, it's neck to neck, exactly. One is maybe. So let's go.
Let's go. We'll sit. We'll sit in
Let's go and sit in the room.
Everyone, please remain seated as we will soon begin with the valedictory session also. After the valedictory session, everyone please settle down. After the valedictory ceremony, we shall have a short lunch for which we shall distribute coupons amongst all of you. Please remain seated and settle down. Thank you.
हमारे पास 5 मिनट स्टेज शो करने के लिए उसके बाद